Ms Patten, please.
Thank you, Acting President. My adjournment matter is for the Attorney-General, and the action I seek relates to the barriers to claims made by mothers whose children were forcibly adopted. As many in this chamber would have known, in 25th of October in 2012, the Victorian Parliament issued a formal apology to those harmed by past adoption practices in Victoria and acknowledged that as many thousands of Victorian babies were taken from their mothers without informed consent. And I'd just like to quote a little bit from that apology. We express our sincere sorrow and regret for the health and welfare policies that condoned the practice of forced separations. These were misguided, unwarranted, and they caused immeasurable pain. Between the 1950s and the 1970s, as many as 250,000 babies were taken from their mothers as a result of the state government forced adoption practices. However, given the passage of time between the conduct and the apology, claims for damages are barred by the Limitations of Actions Act 1958. Just as the Limitations of Actions Amendment Child Abuse Act of 2015 removed the limitation period that applies to causes of action relating to the death or personal injury relating from child abuse. So that limitation was removed to enable historical child abuse cases to be heard and compensated for. So the action that I seek is that the Minister apply the same reasoning and consider establishing a mechanism to compensate mothers whose children were forcibly adopted.